Appellate Division 4th Department. Hear ye, hear ye, hear ye. All persons having business to do before this court will draw near, give their attendance, and they shall be heard.
Thank you. Please be seated. Good morning. Our first case for oral argument today is People v. Ross, case number 253. I have been given the wrong set of papers here. Yeah, if you can get the other large stack of papers from my chambers, that would be appreciated, but we will proceed in any event. Case number 253, People versus Ross. We have appellant is virtual. Mr. Haydu, you may commence your argument if you wish.
May it please the court, Lyle Hoydu for defendant Ross. Unless the court directs me otherwise, I will focus on the first 2 points of the brief, Your Honor. In this case, defense counsel was ineffective for failing to explore a viable psychiatric defense. Excuse me. In this case, there was overwhelming evidence that the defendant was an untreated schizophrenic off his medication, that he was experiencing paranoid delusions at the time of the incident, which included delusions of people following him, shooting his tires, trying to harm him, even the female victim in this case having hired a hitman to try to kill him. And all of this is documented by the police in a 911 call. So we have proof that the defendant was operating under extreme emotional disturbance and delusions that the girlfriend intended to murder him, which is a viable psychiatric defense that should have been explored by defense counsel.
Counsel, though, if that defense had been successful, then the result would have been, the felony would have been dropped 1 degree. He's still a mandatory persistent violent felony offender. That defense would have subjected him to a life sentence, would it not? Even if successful.
If successful, yes, Your Honor.
Mandatory life sentence if successful. So couldn't counsel have looked at it and said, well, even if I win on that, my client's not going to be too happy? Your client's defense was he didn't do it, right? He testified, if I recall, and he said, I didn't do it. And that's to say that he was emotionally disturbed when he did it would have been inconsistent, right?
Well, perhaps on the emotional disturbance, but he also could have been found not responsible by reason of mental disease or defect because of the paranoid delusion. So with regard to the EE defense, if you look at the math in terms of the sentencing, it may not have moved the needle, but certainly the disposition of not responsible by reason of mental defect would have had an entirely different outcome, Your Honor.
We don't have any evidence here that he did have any mental disease, but I suppose he could always bring a 440 if he had some evidence to that now. But right now, there's no medical evidence of that in this record?
In large part because defense counsel failed to explore a viable defense. It was documented in the probation report that he had mental health issues dating back to when he was in high school, Your Honor. And
right, no, I understand. But all I'm saying is that if he does have such proof out there and counsel didn't submit it or didn't rely on it, it seems like his avenue, like a lot of these types of claims against attorneys, might be better pursued at a 440. But you do have another argument I believe you want to get to?
Yes, Your Honor. Excuse me. With regard to the, we think the court erred by allowing, excuse me, testimony about these prior bad acts and the underlying facts of prior convictions. It served no legitimate purpose in this particular case other than to paint the defendant as just a criminal who has a propensity to commit crimes against women in their home. And we have the recent case of Weinstein, where the court examined our Molinol and our Sandoval rule, which are basically two sides of the same coin. And, Weinstein was very clear that a trial should be about the crime charged, not past conduct or past
Well,
crime.
Weinstein was a Molyneux case. Here, the court's Molyneux ruling was quite limited, dealt with other evidence. I think you're referring to the Sandoval ruling. The court, if the defendant took the stand, he could be impeached with certain evidence, but that evidence wasn't allowed on the People's Direct case, if I'm not mistaken.
You're correct, Your Honor, and I do group it together just because Molineux and Sandoval, again, being so intertwined. But in this case, they allowed the defendant to be cross-examined about his prior convictions. I wouldn't necessarily have an objection to the fact that he has a prior conviction and they can set forth what the charge was and the year that it was entered. The problem comes is when they get into the underlying facts. And when you look at the Weinstein case, they say that you still have to have that balancing of the probative value of that evidence coming in weighed against the potential for prejudice. Mm-hmm. When in doubt, the court should preclude the evidence so as not to prejudice the defendant. And in this case, there was no balancing test whatsoever.
Well, didn't think when you say there's no balancing test, didn't the court limit as far as some of the older, more stale cases? They precluded the prosecution from bringing those up, and as far as questioning, limited questioning with respect to several others. So there was some balancing done by the court below.
Well, right, with regard to the older convictions, Your Honor, but I'm the ones that came in, for example, where the jurors were allowed to hear testimony of 3 of the 4 cases that are remarkably similar to the facts in this case. What purpose did that serve? If the Sandoval is to address, to challenge the credibility of the defendant, showing that he puts his interests above those of others, then why were the facts of the convictions introduced? It served no purpose.
Yeah, I'm not sure I agree with you that the facts were remarkably similar. This was a domestic abuse beating, and there's no burglary here. The cases that I think you're talking about he was impeached on were just run-of-the-mill burglary with strangers with no violence. But we understand your point that it should have just been, he should have been asked whether he was convicted of a felony rather than the facts of those felonies. And we'll take a close look at that.
Appreciate it, Your Honor. Thank you.
Thank you.
May it please the court, Jerry Marti for the people. As to the first point, I just want to point out that the Sandoval compromise in this case was better than the one in Sandoval. In Sandoval, it was a murder conviction, and the prosecution was allowed to get into questions, including the underlying facts of a disorderly conduct and assault in a 3rd degree. Here, the Sandoval compromise, the prosecution wasn't even allowed to get into the assault-related convictions. As to the second point, in terms of ineffective assistance of counsel, it was clear that the defendant wanted to pursue the argument that he didn't do it. When there was
right, he testified. Do I have this case correct?
Yes, he testified.
And he said, "Wasn't me. I wasn't there."
Correct. Your Honor.
But I guess counsel's point is that in the alternative, there's nothing wrong with arguing in the alternative. It wasn't me, but if I was insane at the time. I guess that's a strategy. I'm not sure how good that one is.
Well, 2 things. One, when looking back at a mere losing strategy, that's not enough for ineffective assistance. But going to your point, defense counsel had an opportunity to speak with his client on various occasions. When they had the pre-sentence interview, the defendant himself said he was okay and he wasn't taking any medication. So under this record, there was no evidence that there was any support for an extreme emotional disturbance defense. Unless there's any questions, there's one more point I want to address. I want to address the last point. The defense defendant raised an Erlanger claim for the first time in the reply brief. Just want to point out, the people did not have an opportunity to address this. As far as the procedural aspect, it's waived because it's raised first in the reply. That's the O'Sullivan case decided by this court. It's also not preserved. There was no constitutional challenge or objection.
I think the Court of Appeals just ruled on the preservation issue last week. We're aware of that.
Okay.
Case, as I'm sure you are as well.
Yes, Your Honor. Unless there's any other questions, I will rest on the remainder of the brief.
Thank you.
Thank you.
Case 254 is People versus Taft. Counsel for appellant, we are waiting for him to appear virtually. You may begin.
Thank you, Your Honor. Good morning, and may it please the court. I'd like to focus on the first point in our brief, unless the court has questions about any of the other points. The lower court here erred in proceeding in Mr. Taft's absence on both the first and the second day of trial. Our position is that the court committed separate and distinct violations of Mr. Taft's right to be present on both of those days because it did not conduct a meaningful inquiry or set forth on the record the reasons it relied on to conclude that Mr. Taft's absence was deliberate.
No, but you can see you're not challenging Parker warnings. He was given the Parker warnings, and that's not your argument. You're arguing more Brooks than Parker.
That's correct, Judge. I think as I'm sure the court is aware, the Court of Appeals made clear that just because a court provides Parker warnings and the defendant then does not appear in court does not mean that the court can automatically proceed with trial. Instead, the court must exercise its discretion after considering all of the appropriate factors. And our position is that the court here simply failed to exercise that discretion. And that's evident from the morning of the first day of trial when Mr. Taft was, I believe it was 15 minutes late on the first morning, and defense counsel advised the court that he had spoken to Mr. Taft about 20 minutes earlier. For some reason, Mr. Taft had gone to another court but was on his way. The court simply pressed on. A few minutes.
Nothing of significance seemed to happen during those minutes that he was a few minutes late. You're not challenging that as a violation. I think, are you looking at the afternoon on the first day? When you talk about first day.
I mentioned the morning just because it shows a sort of a pattern of the court hastily proceeding without any sort of inquiry or consideration of alternatives when Mr. Taft is not there in a timely fashion. But our focus in terms of the right to be present violation is on the afternoon of the first day when Mr. Taft missed approximately 10 minutes of voir dire, and then when he missed the second day of trial. But on the afternoon, again, when Mr. Taft was not present about 10 minutes after he was supposed to be, the court again simply said that it was going to proceed and went on with voir dire without any sort of meaningful inquiry. And I think it's important to note that the respondent's brief indicates that Mr. Taft had made various comments that voiced his frustration and his displeasure before the trial with the process. Nevertheless, he was present at every single one of the 7 pretrial court appearances and was on time for those court appearances. So there was no pattern of not showing up to court.
What do you make of the Smith case from this court, 2021, that Mr. Tantillo relies on? It does seem on all fours. Not a lot of explanation in there, but what's your response to Smith?
Judge, I did read Smith, but I don't, because there was not a lot of explanation there, I don't know what we can make of it. If it's the Smith case that I'm thinking about, I believe it's the one that the respondent's brief indicates that this court can place a lot of weight on the fact that a defendant does not show up for a second, third, or fourth day of trial after having shown up. I don't think Smith or Ligamari actually say that there's a greater weight to be placed on a defendant's failure to show up after he has been in court on previous days. The other cases that do describe the circumstances of what happened that the respondent's brief relies on, and I think particularly People v. Green, People v. Mejia, and People v. Chestnut, all involved situations where a defendant left following a midday break. So People v. Green is a key case that the respondent's brief relies on. There, the court specifically advised everybody that we are taking a short break. Don't leave the immediate vicinity of the courtroom. The defendant disappeared. Under those circumstances, it's readily apparent that the defendant's absence must be deliberate and there's nothing else that could be going on. And in that sort of a case, the court need not place on the record the reasons for proceeding. What I think is critical in that in Green, in Webb and Chestnut, all cases that the respondent relies on, in each of those cases, the court took some steps beyond merely proceeding with trial. The court took a brief adjournment, whether it was either an hour or it was a day. The court gave defense counsel and the prosecutor an opportunity to contact the defendant, to contact police departments, jails, or hospitals. And it also, at least in Green, had a hearing later in the day to describe the efforts made by the DA's office in an attempt to locate the defendant. Nothing along those lines was done in this case. The court simply hastily proceeded with the trial. And under those sorts of circumstances, especially where there is no history of failing to appear, our position is that there is a right to be present violation. The last thing I will note is that respondent's brief also argues that the deliberate nature of Mr. Taft's absence is apparent from subsequent events. 2 points with respect to that. Because there are two distinct right to be present violations here, subsequent events, I think, shed no light on whether Mr. Taft's absence on the afternoon of the first day of trial was deliberate or not. With respect to the second day of trial, the respondent's brief points to defense counsel's attempts to locate Mr. Taft being ignored, and the fact that Mr. Taft was arrested on the bench warrant approximately 4 days after trial. The record
after a high-speed chase and so forth. But I think you may be right. I don't know. You may be right that subsequent events can't justify the court proceeding without at least inquiring and making a finding that it was deliberate his absence. But what if in this case, your client, there's a warrant, they find him, he leads the police on a high-speed chase and barricades himself in the house. What if he comes out and says, the police officer says, "Why didn't you come to your trial?" And he says, "Well, I deliberately did not want to be there." The trial court and us, we can't rely on that as evidence that he deliberately absents himself from the trial. If he admits it,
I think
it's a new trial anyways, I guess, under your theory.
No, Judge, I guess just to clarify, I don't dispute that as a general matter, subsequent events can illuminate whether or not a defendant was deliberately absent. So I'm not arguing that the court simply cannot consider subsequent events. We make a number of arguments. First, in terms of Mr. Taft ignoring phone calls or text messages, there's no evidence in this record that he quote unquote ignored them. He did not respond to defense counsel's text messages and phone calls, but that's because he said he was attending to his daughter's injuries and when she had to go to the hospital. Mr. Taft did contact counsel the afternoon of the second day of trial to inform him where he was. At that point, defense counsel advised him of the bench warrant, and while obviously he did not turn himself in on the bench warrant, the fact is that he may not have turned himself in because he was worried about being taken into custody and being held in custody, and not necessarily because he had deliberately decided not to attend court earlier in that day. So our point, I guess, with respect to the bench warrant and this alleged chase is that it's equivocal. And had the court conducted an inquiry, it might have made it unequivocal that he did, in fact, deliberately decide not to attend court. But
an inquiry after he was arrested, or at the time he didn't show up for the trial?
at the time, he did not show up for trial. The last point I know, and I cite two cases. I believe it's another People v. Smith case as well as People v. Trotman, where in other contexts, this court has said that bare assertions by a prosecutor about things that have happened are not sufficient to substantiate either a request for a missing witness instruction. But I would respectfully submit that those bare assertions should also not be sufficient to justify the right to be present violation in this case. The court could have easily requested sworn police reports or called a witness to testify at a hearing to substantiate those allegations, but did not. And so for all those reasons, I would respectfully submit that on both the first and second days of trial, Mr. Taft's right to be present was violated.
Thank you.
Good morning, Your Honors. Michael Tantillo for the respondent. As you indicated, Your Honor, this defendant received Parker warnings on 6 separate occasions about his necessity and obligation to be present for trial. Obviously, in light of People versus Parker and People versus Brooks, it would have been the better course of action for the trial court when the defendant failed to appear to conduct an inquiry into the reasons for that. But there is one case, and you alluded to it, Your Honor, that specifically addresses the situation where subsequent facts confirm or justify the court's determination to proceed without such an inquiry. And that's People versus Mejia, I believe, Mejia, M-E-J-I-A. It's a First Department case. And they said, even in a situation where the court fails to conduct an appropriate inquiry, we would find no basis for reversal because subsequent events confirmed the deliberate nature of the defendant's absence. I could find no case that challenged or contradicted Mejia, but I did find a couple of cases which I cited in my brief that also alluded to subsequent events, at least as partial justification for upholding the judicial determination to proceed.
That sounds like a harmless error type of analysis, and that the court did not inquire here, as you recognize under Brooks. You're supposed to inquire, make some efforts, check the hallway, check the hospitals. That's what, when Brooks was decided, Parker, we didn't have cell phones readily. Now, I don't know why you wouldn't say, can you just call your client? We know he has a cell phone because prior, could you just call him, see where he is, if he's coming? And the court didn't even do that minimal inquiry. So there was a violation there, but what you're suggesting is it was obviously deliberate. We know now it's obviously deliberate. So that washes away the Brooks error.
I'm not going to say it washes it away, Your Honor, but I think it is definitely worth considering. I can't challenge what the court did. I can't, unwash what the court did. And certainly Brooks makes it clear that he should have conducted an inquiry. But in a case like this, we have evidence that the defense attorney tried to call his client, didn't get an answer, texted his client, didn't get an answer. Later did tell his client, the judge has issued a bench warrant for you. You have to appear. Never appeared, never showed up after that. And in fact, days after the verdict, when he was located, he leads the police on a high-speed chase, gets to a house and barricades himself in. So I can't think of anything more compelling to conclude that the defendant's intent was to avoid his appearance at the trial. So you also alluded, Your Honor, to the People versus...
Wasn't the defendant present at all the pretrial hearings?
He was, Your Honor.
Right. I mean,
he was. When I said that he had failed to appear, he had a history, what I meant was his being late on the morning of the first day and be late on the afternoon of the first day.
Even being late on the first day, wasn't there a time where he was in the building or was on his way? Even the prosecutor indicated to the court, hold on, he's in the building, he's coming, and
that's all correct.
And basically said, we're still going.
That's correct.
Right.
But on the morning of the first day, the only thing that took place before he appeared was housekeeping details.
I understand that, but it still doesn't justify the fact that the court didn't make any inquiry, just went
I
on.
can't argue against that, Your
They didn't
Honor.
even wait, or, even under Parker situations, you can adjourn the situation to determine
Yes.
whether things are deliberate.
Yes, I understand that, and I know that, the cases kind of make that clear. But in this case, the subsequent events, I think, do warrant this court taking into consideration those factors rather than allowing the defendant to benefit from his own obstructive actions.
Sounds like the mistake here was that the trial court thought Parker was the only consideration. Because he did give,
The Parker warnings.
Parker warnings. And that once the defendant doesn't show up after Parker warnings, you either start up with nothing, no inquiry, nothing. And that is contrary to the law as you understand it. But I think that was the mistake here. And just as Montre made an important point is that even under Parker, doesn't mean you have to go forward, right? That's one option and you have to consider other options, but that was a mistake. But it is hard to disagree with you that his refusal to come back to court on the second day, the third day, didn't respond to anything, and running from the police do indicate perhaps that it was deliberate. It wasn't a mistake. Like he says his daughter broke in his arm and he wasn't a custodial parent.
I think that's the only rational conclusion you can draw. But I would also note that there is a caveat in Parker that indicates that a court doesn't necessarily have to make that inquiry if it is apparent that it would be fruitless. Now, it doesn't say if it's apparent at that moment or if it's apparent later on, but there is that caveat in there as well.
Yeah. All right, we'll take a close look at it.
Thank you.
Thank you. Case number 258.
What about 255?
I'm sorry, 255. Thank you, Justice Smith. 255 is People versus McCants. Morning.
Morning. May it please the court. I'm Tanya Plank for Andre McCants. The court erred by imposing an inappropriate, meaningless sanction for the People's Discovery violation under CPL 245.80. The court correctly determined that the people violated CPL 245.20 by turning over Officer Wilson's body-worn camera on the eve of trial.
And then the judge then precluded that in the.
Yes, he did. The judge precluded the body-worn camera and the officer's testimony as to what was on the body-worn camera. So our argument is that while that was an appropriate sanction.
Wasn't it, how can that be meaningless? I mean, that body worn camera showed that the defendant was
Right.
actually served with the order
Right.
of protection. So obviously that's
Right.
fairly
It's just-
significant.
Well, I'm saying it's meaningless because it was tantamount. Then the court allowed the officer to testify from memory about the serving of the order of protection. And I'm arguing that rendered that's a meaningless sanction because if he's allowed to testify from memory, then he's basically testifying to what was on the body worn camera because there's no way he could have remembered a year and a half later that the exact date on which he served the affidavit or the order of protection, especially when the affidavit was misstated. And he testified to the grand jury, which was shortly after the serving of the affidavit, that it was served on the 20th instead of the 21st. So it just doesn't.
This, as you know, this case commenced before Article 245 took effect. Article 245, the new discovery.
Yes.
Not so new
Yes.
anymore.
So but I would argue that the court that any argument that 245 doesn't apply would be unpreserved for appellate review because the court held that it
Would you
did
agree
apply.
that
So
it's an open question at the Court of Appeals under Rufus King, right?
Right.
But
Right.
I think if I'm not mistaken, the argument that was made that you're making is that even under the old discovery laws,
Right.
240, not 245.
Correct.
Under 240, you had to ask for certain things. If you're
Yes.
the defendant.
Yes.
If you don't ask for them, you don't get them, and there's no discovery violation. But if you ask for them
Right.
and you don't get them, then you have a discovery violation.
Right.
It's not tied to 3030, but you're not
Right.
even challenging 3030 here anyways, right?
Excuse me. No, there was no 3030 issue here because the
Even-
time hadn't run because of the executive orders.
Right, because
Right.
there's not enough time.
Right.
So even if 245 applies, it's not a speedy trial thing, it's just a sanction.
Right,
But my
Right.
point is that let's assume that 245 doesn't apply because this case
Okay.
commenced before the discovery law took effect. Is it still a violation under the old rules, 240? And if so, like what was the request
well,
for this type of evidence?
defense counsel did request that. He did request it in his omnibus motion.
He requested body.
He
cam
requested,
video?
yes, he requested all recordings, all taped recordings, which would have included body worn camera.
Yeah, I thought it might have been a little more ambiguous than that, but I'll take your word for now.
And in relationship to the fact that, that you're indicating that the body worn camera was precluded by the court and any testimony in relationship to it. The affidavit of service was admitted, wasn't it?
Yes, the affidavit was admitted.
And the affidavit of service was dated, I think, February 25th, if I'm not mistaken. And this incident occurred on March 2nd. So.
Well, no, it was dated, the affidavit of service, the date on which he served it was
Right, but
February
when he
20th.
filled out his affidavit of service, he
Yes.
filled it out on the 25th, which is still earlier than the time of this incident. Because the
time of the March
violation
incident.
of the order of protection occurred, I think, on the 2nd of March.
Right,
So that's evidence that it was served, that the defendant was well aware of the fact of this order of protection, was served with it beforehand, before the incident occurred, and was rightfully charged.
well, I'm not, and the issue, I mean, the argument that defense counsel was making for being prejudiced is that he was given this evidence right on the eve of trial, and he didn't, his defense was going to be that there was, that the order of protection, the service of the order of protection was problematic, and that destroyed his defense. And so that's the problem, the harm, I think, with the prejudice. If there are no further questions, I'll rely on my brief for the second point.
Thank you, Counselor.
Thanks.
Good morning, Your Honor. Nesterenko for the people. I would submit that the court did not abuse its discretion in not imposing a more severe sanction. I think the evidence, apart from the body worn camera footage and apart from even Officer Wilson's testimony, is clear that the defendant was aware that an order had been issued and he was in violation of that order on March 2nd when he went to that home. Unless the court has any further questions, I would rest on that.
Thank you. Now we will hear 258, People versus Durant.
Morning, Your Honors. Kathy Bearden on behalf of Appellate Durant. Excuse me. He was tried and convicted only under count 4, the robbery, first as an accessory. We'd submit under both legal sufficiency and weight of the evidence, the proof was clearly insufficient in terms of whether he or not he aided the co-defendant. Again, he's not involved in the murder, just the robbery. And I think the video itself is really telling. I've looked at it multiple times. I'm sure the court has too. His failure to act to save the victim doesn't equate to an intent to aid the co-defendant.
He's not a good Samaritan. Matter of fact, he's a bad Samaritan.
I can't disagree with you there.
Casually, this guy just gets shot and he's dying, and your client just casually walks off, checking his watch as if he got not a care in the world. But you're saying that doesn't mean he shared the co-defendant's intent, or
Correct.
he was definitely there. I guess what Mr. Swally argues about is that the fact that your client didn't run when the shot rang out, like everybody else did, indicates some level of knowledge and intent. The video, according to the people, show your client in the street when that state trooper drives by, as if he's trying to hide what's going on there between Coley and the victim. And that's where the intent and accomplice liability comes in, albeit rather thin, but that seems to be what they're hanging their head on.
Sure. And what I'd say to that are a couple things, and it kind of goes sequentially in terms of the video. There's a whole group of people around the individual when he was shot. It wasn't just my client. When it appears that the
That's when he was shot, though, but then when the co-defendant chases him down, the only person who according to the video, followed was your client.
Actually, there was another individual who followed before my client did, and he went into that little, I think it was an alleyway. My client also went into the alleyway. They both came out. There's no proof from the video that that individual who they say scampered ran away. He walked out. If you watch the video, he walks out, he makes a left. He simply just walks. He's not running. He seems to put something down on the ground. I can't tell what it is. And then he gets in his car and he drives away.
And counsel, not to interrupt, just to follow up on Justice Monter inquiry. Unless I'm confusing, I thought after your client was in the street when the trooper car went by and after allegedly someone ruffled through the victim's pockets, I thought that your client and the other person walked away together.
They did. They did walk. They did.
They walked past the store, walked past the parking lot till they're out of view of everyone.
They did. Again, as he's walking and the co-defendant who shoots him goes over and rolls the pockets of the victim. My client walks behind them, walks out into the street, stands there for a few seconds. The trooper drives by and doesn't stop. My client doesn't do anything. He doesn't block him. He doesn't move at all. He's actually just standing there.
Isn't he moving in a direction as the car is moving, the trooper's car is moving, and then he's sort of going in the same direction, walking, and he's some distance from the co-defendant and the victim, which sort of acts as a shield. You know, if like a goalie, you're going to get out further than from the net, you know, to shield more of the net.
Well, I think actually, I mean, my interpretation of it is he's just standing there. He doesn't actually move when the trooper car comes by. He's standing there and the car drives by.
It was a very convenient location for him to be for his co-defendant.
I don't disagree with that, but there were other cars that had gone by as well. So if he's just standing in the street and the car happens to drive by, he's not obstructing traffic. Nobody comes in the lane closest to the victim. And there's a car or two that comes before the trooper vehicle. And Mr. Durant is just standing there. Again, he walks over with the other individual, with the co-defendant, and leaves. I mean, they raise a question about, you know, it appears that he pulls something out of his pocket. To me, it looks like a cell phone. It's really hard to tell, but what you can tell later on is what he's carrying in his left hand is a water bottle. And it's probably because the light is reflecting through the bottle. It's kind of hard to tell. Again, I think in my brief, I indicated his actions they are morally reprehensible, but does that rise to the level of him serving as a lookout? And essentially, I just don't think that there was enough, not only from the witnesses.
Well, it was a lookout after the fact too. It wasn't a lookout. It appeared spontaneous from my viewing of the video that Coley, because the victim, Mr. Kennard, I think his name was.
Yes. Correct.
He was just hanging out there.
Yeah.
Outside this grocery store for a while. And it looked like words were exchanged. It looked like it had been a dispute that arose almost spontaneously between Coley.
Yeah, I agree. That's what it appears to be.
So that militates in your client's favor.
Sure.
Right? How
No
can you
plan.
intend to do something that somebody else does spontaneously? Right. But yeah, so we'll have to take a look. Do you want to be heard on the Batson issue? And if you could clarify, is your contention with respect only to the prospective juror number 2, I believe Smith was the last name? That's the only one you're challenging on appeal?
Well, I am challenging all 3. I understand that the first 2 weren't necessarily preserved. I don't think either of the defense attorneys objected in terms of when
they've already been discharged and probably home by then, right?
They probably were.
So there's no remedy there for those first 2. So it sounds like you're really going to focus on juror number 2 on the 3rd panel.
Right. And again, I think their argument was it was a plan to them because really the basis for discharging those first 2 jurors, one didn't answer a question, but then she wasn't asked any further questions after that. The second one, they said she had floaters in her eyes. I have floaters in my eyes. I can still see video.
I think Mr. D'Amelio's reference to those first 2 who had already been excused without objection, he was using that to get to the step 1 burden of a pattern.
Yes.
He wasn't necessarily challenging them per se.
Right.
So then we have the prosecutor jumps in with a facially race neutral reason for striking number 2. Couple of reasons.
Right.
And the court then denies it on step 1.
Yes.
The court goes back and says you didn't show a pattern.
Yeah.
We have cases that show once the prosecutor goes to step two, the racial neutral reason, step one is in the rearview mirror. And so your argument is the court can't deny it on step one when the prosecutors
No.
are already at step two.
Right.
And the court never ruled on step two.
No, they
Right.
didn't. And when you get to the third person, I mean, the DA's argument is, well, he didn't completely, or didn't fill out, I think to their satisfaction, the sheet of paper that they had to fill out, but also that he was, I think they said slumping or whatever, his
Slouching.
chair. And Mr. D'Amelio points out, well, so is juror, whatever it was, 6. He's doing the same thing. The difference is we have an African-American juror here and juror number 6 isn't. So
If you're right, that the court erred on denying the Batson challenge on step one, when the prosecutor already kind of conceded and got to step two, the remedy would be to remit for a ruling from Judge Argento on whether the reason was race neutral, and then give Mr. D'Amelio or Mr. Morbido
yeah,
an opportunity to argue pretext,
correct.
right? It wouldn't be a reversal and a new trial at this point. If we
I
agree
think
with
I have to
everything
agree
said.
with you, yes.
Okay.
Counsel, if I
Yeah.
may, is it your position that the court did not get to step 3?
I don't believe that they did.
Because, I mean, defense counsel responds with respect to the one juror that's at issue
Right,
here.
correct. Mr. Smith, I think his name was.
Right, and so that's our step 3, and then it was incumbent on the court to render a decision.
Right, to make a determination. And then-
And Justice Lindley makes a point that the grounds that the court relied on appear to be a step 1 ground. Correct?
Correct.
But the court did deny the
They
motion,
denied the motion.
And it could have been an implicit denial then at that point.
Could have been. I think there more had to be done.
I mean, if the court had just said it's denied, that would have been sufficient to at least get for the court to have made a determination.
Right, but I don't think we got to that point. I think that was the problem. I
Right.
think that
If
was the issue.
we have a lot of these implicit denial cases on step 3, the prosecutor gives a race neutral reason, the defense lawyer argues it's protectual, the court just says, I'm denying the motion. We say it's implicit, we're implying that the court denied it, that it was not protectual. Here, I guess your argument is we can't imply that much. We can't infer the court reached the issue on 3 because the court explicitly said, I'm denying it because you didn't show a pattern, which is step
Exactly.
1.
You said it better than I would have, Judge. Yeah. And just briefly, I wanted to go to the harsh and excessive. Again, I think the proof didn't rise sufficiently anyway, but he was sentenced 3 times the minimum on this.
What did Coley get for the?
Coley got a total of 45 to life. So I suspect it was 25 to life, and then
So there's he's more culpable, so there's no
he's
argument.
clearly
there.
more
I
culpable.
didn't realize, I thought he got less than 45.
That's his, Docs has him as 45 to life.
I think it's for other crimes though. I don't think he got 45 on this, because he got it down to manslaughter.
He got down to manslaughter, but I
So-
suspect it was probably at least 25. I looked and I couldn't find it. Perhaps the prosecutor can
Yeah.
expand on that. But again, I mean, 3 times for standing there. Number one, he clearly was apologetic. He expressed extreme remorse to the family and to the mother, while saying, look, I had nothing to do with this, but I lost a family to gun violence as well. I just think everything mitigates against this kind of sentence in a situation like this, like the facts that are presented here. So if the court doesn't vacate based upon my first argument, I would request that the court reduce the sentence substantially, but the minimum, I mean, it was a 5 to 25, and the court split it roughly by half, in half
Well,
essentially.
the court gave him 18.
18.
Yeah.
Bad
So maybe,
math.
maybe your math is right. I don't know. I don't have my calculator.
I'll take
handy.
your word.
Yeah.
It's mine.
All right.
mine-
Well, thank you.
Thank you.
Good morning, Your Honors. Again, Aaron Schweif for the people. With respect to accomplice liability, I think the evidence is clear that defendant acted as a lookout for the co-defendant as he robs Mr. Kennard.
Okay, yeah, during the robbery. And he was only convicted of robbery, right? So you're not saying he was a lookout or he had any intent on the murder
No,
or the homicide?
correct, Your Honor. What I think is important, the most important piece of evidence in this case is the surveillance video outside of Roland Grocery. And you have 5 people standing outside of Roland Grocery. You have defendant, co-defendant, Mr. Kennard, the victim, some unknown individual, and Mr. Burris. And when the shot rings out, the 2 people, Mr. Burris and the unknown man, scatter. They run, as anybody would that's innocent, doesn't want to be hurt, doesn't want to be shot, doesn't want any part of this. The defendant, in stark contrast, walks coolly, calmly, casually after the co-defendant as he essentially stalks Mr. Kennard as he staggers backward and eventually lays dying on the street. He then chases the unknown man out of an alley who sought refuge in that alley. He looked toward a car with its lights on. And, he looked again toward that car. The car eventually drove away. But we eventually learned that car was driven by Mr. Smith, who said that he was looking to see who was looking. We also have Ms. Harrell's testimony, who stated that he was looking in the street. The evidence that he was acting as a lookout, I think, is overwhelming. And we also, it's obvious that defendant and co-defendant are together before, during, and after the shooting, after the robbery.
Do we know if he shared any of the pros? It looks like they took, Coley took his wallet. I mean, he was in his pockets for quite a while. Cell phone, wallet, whatever he may have taken. Is there any indication that our defendant here shared any of those proceeds? Not that that's determinative, but I'm just asking.
Sure. So with the larceny component, what I think is clear from a different angle, a different surveillance video, is that Mr. Kennard is shot. The co-defendant's clearly rifling through Mr. Kennard's pockets, his person. And at one point, he removes his hand from Mr. Kennard and puts it in his back pocket. We can't see explicitly or clearly what was put in his back pocket, but there's no reason for him to make contact with his back pocket other than to put something into his back pocket. In my opinion, that was almost certainly cash from his wallet. But as an alternative theory, he threw the wallet into the street, thereby, disposing or preventing Mr. Kennard from ever collecting that wallet again, because he was laying dying in the street. He couldn't move. And he also couldn't tell police officers or EMS or firefighters that responded what had been taken, because he couldn't talk. So I think it's clear that a larceny had taken place, that the co-defendant had collected property from Mr. Kennard. And as he collected that property, defendant was serving as the lookout.
Would be heard on Batson?
Sure. So I think the one preserved issue was Mr. Kai Smith. The people stated that he filled out very little in his juror questionnaire. And there's so much case law that when a juror is not forthcoming with prosecutors or any party, whether it be in the juror questionnaire or during jury questioning, that's a race neutral reason to challenge that juror. So
the court didn't deny the Batson claim on that basis, right? The court denied it on the defense didn't show a pattern. So can we affirm on race neutral grounds when the court under Concepcion, when the court denied the motion seemingly on a different ground?
On the Concepcion issue, I'm not entirely sure, Your Honor, but I would just submit that there's clearly a race neutral reason here. So even if it were remitted, I think the inevitable result is, we all know what that would be, that there was not a pattern here.
But we just can't say, well, the defense is going to lose, so we're just going to have them lose now. We would have to send it down so we can lose. But I mean, maybe not. If it is a race neutral reason, Mr. Morabito would be able to argue that the prosecutor, that was pretextual, which is just a nice way of saying that he's lying. Right? That's what pretext is. Like, you struck him because of his race, not because of these other reasons. And then conceivably, he could make a good case on that. And the trial judge may rule for the defense or not. And then it would come back to us and we could make the determination whether it's protectional. Granted, I mean, we don't reverse on that very often, but that's how it would work, right? Procedurally?
Procedurally, I suppose that's correct, Your Honor. And with respect to harsh and excessive, I would just submit that the sentence imposed was 7 years below the minimum. Defendant's history may be primarily composed of misdemeanors, but it's nonetheless exhaustive and it evinces a pattern of theft. And I suppose the callousness of this crime speaks for itself.
Is a prior felony?
I believe he
He had misdemeanors. I think.
he had misdemeanors. That's
Yeah.
correct, Your Honor.
Okay. All right, thank you. Case 259, Thayer versus Darling. Owen has submitted and we have Miss Gray as virtual. Chido is here with us. We're waiting for Miss Gray. There you go. Miss Gray, good morning. You can unmute yourself and begin your argument, please.
Thank you. Your Honor, I represent the child Faith in this matter. She is 12 years old. She changed her position from her initial position at trial. She has been living with her father for over 2 years, and she wishes to stay in that residence. I believe that the trial court made a very reasoned decision. Certainly, it's a lengthy decision, relying quite a bit on the credibility of the witnesses. And to update the court, Faith is doing well. She's involved in track at school. She just spent a week with her mother in North Carolina because the parties did reach a visitation agreement in family court in December. So she will have and will continue to have contact with her mother. She did want me to tell the court, although I know this court doesn't have jurisdiction to change the terms of the December agreement. She wants to spend summers in New York because, of course, as a soon-to-be teenager, she'd rather be with her friends than either of her parents. But unless the court has any other questions, I rely on my brief.
Thank you.
Good morning. May it please the court. Michael Caputo, attorney for the child Joseph Darling. I've met with Joseph at school. He's 8 years old. He's in 3rd grade at Sodas Elementary. And as Ms. Gray noted, the children have diverged in their positions. Previously, both children wanted to return to North Carolina to reside with their mother. Joseph remains desiring to reside with his mother in North Carolina. The bottom line in this case is that the mother, Tiffany Thayer, has been the children's primary caretaker their entire lives. And father, Mr. Darling, although he's a good dad, has been a long distance father very frequently. So it makes sense why Joseph wants to reside with his mother. And as far as an update, as Ms. Gray noted, visitation is occurring. The children went to North Carolina for February break this last week, and phone calls are occurring. Joseph is doing well in school. He's getting 3s and 4s. And the last thing, Your Honors, is that if Joseph moved to North Carolina, he informed me that he would miss his sister, but he would not miss her yelling at him.
You're advocating for splitting up the 2 kids?
Yes. I would request that the court modify the order below to grant custody to the mother without any conditions and remand for determination of father's visitation time. Joseph would like to see his fathers in the summers here in Rochester. Thank you.
Thank you. We'll call case 260 and case 266 together. This is the PB 77 Doe case versus Lutheran Church, Missouri Synod. 260 and 266.
May it please the court, I represent the plaintiff appellant known as PB 57 Doe. The name's Victoria Phillips. And if I understand correctly, I should make my argument respecting both the LCMS or Lutheran Church.
It sounds like you're treating all the defense kind of similar, which is understandable. So it doesn't sound like your argument's going to diverge at all. But that's up to you if you want to argue one first and one second. But I think it makes sense to just do them all together.
I think there's some logic to that, because I think if you look at the Constitution, if you look at the evidence in this case, it's clear that the Eastern District is an arm of the Lutheran Church Missouri Synod. And, you know, that we think that's either readily apparent or certainly something that a jury could find, and therefore they could both be held liable. Your Honor, as I'm sure you're familiar from reading the record, this case concerns years of incessant, brazen, open and obvious sexual abuse of children on church and school grounds by a rostered teacher within the defendant's church. The record shows that the defendants, their council of presidents in 1966, gave him a diploma of vocation to work at St. Peter's Church. That's the record at page 529, and page 457 explains that the council that gave him the diploma of vocation was made up of the LCMS and the district. So they installed him, they assigned him.
Just because he was given that diploma from the university or whatever, doesn't mean that St. Peter's was required to hire him, correct?
You know, it's a good question. I don't know if the record is clear on that. St. Peter's had a representative. Her name was Patty Zostro. And I think the diploma of vocation is different from just a diploma like I might get I go on from Williams College, right? This is a diploma to go work somewhere. And he got it from there. And Patty Zostro's testimony, if I remember correctly, is they took their candidates from the roster. So whether in theory they might have been able to, I'd have to look at the record for that point.
Right. Well, their point is that St. Peter's was not required to go off their list. They could hire anyone they want. They could, the defendants, the national organization and the district had no authority under the Articles of Incorporation, the Constitution, and the bylaws to hire or fire anybody, discipline anybody. That's their reading of those bylaws, and they say therefore there's no employee-employer relationship. So this whole thing goes away for the most part.
And that is clearly incorrect, or again, at a minimum, it's a fact issue. And I'd like to look at the PB 20.
Yeah, I know you want to get to the case from last term, but
sure,
that case turned on the specific terms and conditions of the articles in the Constitution there, which are a little different here. Can you point us to where in these articles and the Constitution and the bylaws gives LCMS and the district defendant the authority to hire, fire, or discipline any teachers or employees of the local congregations?
I would be pleased to, because it's almost identical to the Constitution there. And that was my case. So I know that case really, really well. In PB 20, it was the ELCA at the top, the Synod in the middle, and St. Nicodemus Church at the bottom. And it was almost identical in terms of the arguments made by the defendants. They said he was hired, fired, salary was paid, et cetera, by St. Nicodemus. We had no control.
Right, but are the articles in the Constitution the same? And that with the ECLA Constitution in the last case, it looked like it gave the Synod the authority to specifically, it says, to install, because we're dealing with pastors there. We're not dealing with teachers.
Mm-hmm.
And they gave them the authority to hire and fire them, discipline them, right?
Yeah.
They're not under their ECLA Constitution. Is there a similar provision in this Constitution?
There is. And actually
Where's
what
that?
they had in the ELCA case was the power to suspend and the power to remove someone from the roster. And then if a congregation didn't follow suit and wanted to hang on to their pastor in that case, then the congregation could be ousted from the ELCA. That's how it was in that
They
case.
would lose membership.
I'm sorry, yeah, correct. And their
But
property could be seized.
it
And
doesn't
that's
mean that-
exactly what happens
Doesn't
here
mean
as
that
well.
teacher has to be fired or they got to go out of business. They just lose their membership.
They can be kicked out of the church.
Yes.
And any property they have in connection with the, with the broader church could be seized. That was the provision in the ELCA case and PB 20 and PB 21 DOE, and it's the same here. And I'd like to direct you to pages of the record and provisions of the Constitution, because it really, I didn't brief this case below, but I came to it on appeal and almost fell out of my chair when I read the Constitution.
Yeah, if
It's
you could
the
direct
same.
us to the pages, that'd be great.
Sure. So if we look at the Eastern District for starters, I think that is the intermediate level, right? That's Ms. Hilliker's client. Article 12 of the Constitution says the district presidents shall especially.
Do you have a page number on the record?
I think it's record page 583, but it's Article 12 of the Constitution, and it's one Constitution for all three entities, right?
Yeah.
It says the district president shall, quote, especially exercise supervision over the doctrine, life, and administration of the office of pastors and teachers of the district, and acquaint themselves with religious conditions of the congregations of the district. Same page, it says the provision authorized districts to visit and according to as they deem necessary, hold investigations into the congregations. Under Article 12 at the same page, it says district presidents are empowered to suspend from membership teachers for persistently adhering to false doctrine or for having given offense of an ungodly life. Same as in ELCA. Same. Oh, go ahead.
Go ahead. I mean, those sound more like doctrinal controls over the entity. That we're drifting off into First Amendment, aren't we? I mean, those sound to me, as opposed to what we think of supervising an employee for their conduct in terms of carrying out their employment duties. That's one thing. But to make a determination whether you're following the doctrine of the church is something entirely separate, isn't it?
If you actually look at the testimony of Pastor Wicker, who's one of the reverends who testified on behalf of the Eastern District, he was asked about what would you do in cases of sexual misconduct? What would you do today? As you know, he had been the circuit visitor, which is an official that they have from the district going there. He had been the district president, I believe. So he had served for numbers of years later in time in this role. And he said, I would have suspended the guy.
Yeah, that presupposes that the ecclesiastical body is aware of some event at the local church. But without that direct notice, to imply that in terms of providing ecclesiastical supervision or being an advisory body also requires that body to provide attendant supervision as you would as a manager or some other employee-employer relationship, I think is a broad stretch.
I think you're asking two questions and I'm happy to address either of them. But one is, do they owe a duty, whether it's through employment or something else? And there I would say it really is identical to PB 20. And I'm happy to talk about the particular provisions and why. And the second is notice. And I'm happy to address issues of notice too, because I think the court got that very, very wrong.
Right, but first we got to get through it. Notice is irrelevant if you don't get over this hurdle for the employee, right?
The defendants have to owe a duty of some sort. I would say, yeah, you could look at this whole record and say this was a child in their care and they owed in loco parentis duties, which I think given that they established a board of education over teachers would also be a reasonable finding. And under those circumstances, you wouldn't even need notice under your honor's precedent in, I think it's AB 511.
Isn't there more than 5,000 congregations and aren't they acting just as an advisory board?
The answer is the affidavits they provided are about today. So I don't actually know how many there were back in the day because their affidavits are curiously phrased in terms of the present tense, right? They talk about today because that's the knowledge that Reverend Sias and Reverend Wicker had. But setting that aside, the structure laid out in the Constitution
is still the same as far as it's an advisory board.
It's actually, I mean, they said that it evolved over time. So I don't have the Constitution circa 2025. I have the Constitution circa 1966, which is when the abuse was happening.
Sure.
But the answer is they had, and if you read Wicker, he's really very helpful on this, and it comports with the Constitution and it comports with the documentary evidence. They didn't just have an office in Missouri with no contact with the people. They had district presidents who are their regional representatives. And the Constitution is very clear, and Wicker's testimony is very clear. The district has to do what the synod tells them to. The district are agents of it without their own free will. But independent of that, they don't just have the district presidents, they've got circuit counselors, they've got vice presidents. And Wicker talked about how circuit counselors are boots on the ground visiting people, right? So, and that's consistent with the Constitution. Talk about you have circuit counselors, they can visit, they can suspend, they can discipline. It's in Article 12 and 13 of the Constitution. And if congregations don't follow suit, they face serious consequences, just like in PB 20.
Losing membership.
Right.
Which
correct, and
mean,
losing property. I think that's
mean,
Article 13 of the Constitution.
Yeah, well, your opponents will cite Article 7.
I'm sorry, Article
7 of the Constitution on page 578, which talks about the synod is not, says it is an advisory board and it doesn't have any coercive powers over each congregation's right to self-government.
And
is that they rely on that? How is that not applicable here?
That is one.
Because it says advisory board, but you're saying that they have coercive power. They can tell fire this person, fire that person.
They absolutely can. And Wicker's testimony is that he would have done that, right? And CS actually sits on basically the disciplinary committee of the synod. And one of his roles is ousting people who violate the directives of the synod or the LCMS. So they absolutely have coercive power, and it's identical to the power that was possessed in PB 20. But it's not just the Constitution itself. Article 7 is there.
You're
It's
not
one
gonna
provision.
dispute that they had the power to hire or fire this individual or compensate this individual or discipline as far as avoiding the religious tenets of
I'm sorry, who is they? That
the defendants.
Oh.
You couple both the defendants. They didn't hire him, right? They didn't create the compensation. They didn't create his package, did they? They didn't have any control over that.
Actually, if you read the church constitution, they did oversee pensions. And if you read the church constitution, it also says they're going to attend to matters of salary when the circuit visitors go into and the district presidents go into the congregations. So I think there are fact issues on those points as well. They give him the certificate of vocation to go there. That is what enabled him to. Patty Zostro said, we hire people off of the roster. That's what we do. That's what we've always done. And if you read the Constitution, I think we cited in our brief, but there are myriad provisions. For instance, our record at 641 to 642 says that the representatives of the defendants were to give their attention during their visits to many things at Lutheran elementary schools, including teacher salaries, school management, attendance, personal attitude of the teacher towards his profession and pupils. This is 641 to 642. The record also shows not just that these were abstract powers articulated in a constitution, which under PB 20 should be enough to give rise to a fact issue, but it also shows that in practice, we know that people were visiting this congregation from the district who are agents of the LCMS. And let me tell you why. If you look at, for instance, record 1003, right? That's from Dillaway's file. And I will note that Dillaway's file, it's conceded by the defendants, there was a confidential file that was destroyed. So we only have the pieces of it that weren't lost or destroyed at time. So that in and of itself would create problems in terms of meeting their burden on either lack of notice or meeting their burden on duty. They destroyed evidence or they lost evidence. But if one moves past that, the files they did produce, not just the constitutions repeatedly showing supervisory powers, disciplinary powers, powers to remove, etc. It also shows that in practice, people were visiting this congregation. And how do we know that? If you look at record page 1003, there's a history that Judge Scheim simply ignored. And I'd like to talk about why that was inappropriate and inconsistent within the decision and the positions taken by a defendant. But Arnold, I'm going to mispronounce his name, Krumphart, was a district official in the 1960s, and I think later became the president of the district, right? And he advocated for Dillaway, this abuser, in the months and years after he was arrested and convicted.
I will give you, those letters are remarkable, like
oh my God,
unbelievable. Even after he's convicted, that he's still seems to be advocating for him. But as bad as they are for Mr. Krumphart, it does seem to suggest, it sounded like Mr. Dillaway was going to move back to Michigan, maybe to where his family was. Mr. Krumphart in these letters was kind of suggesting, he wasn't never saying he's ineligible to be hired at your schools. He was saying, call me, there's some, he left here under less than that. It wasn't a directive. And that seems to be a little inconsistent, perhaps, is it not, with your position that they could control the hiring and firing?
Let me intervene. First of all, it's not an indictment of Mr. Krumphart and what he did or didn't do after the guy had been convicted of 2 counts of child sexual abuse, right? At that point in time, he saw fit to take whatever positions he taken with a convicted sex offender who he still was going to bat for in ways that boggle the mind.
Yes,
but I really pointed to
blame him as a victim. Like,
I'm sorry?
bad. Even after that, he felt bad for the teacher who was convicted.
Correct. And said, nobody was really hurt by this. I mean, what my client and BG went through, and the 2 girls who were convicted, and these girls lined up nude in front of this man on school and church grounds, having to strip for his pleasure, is beyond the pale. But the reason I pointed to record page 1003 is this. If you look at it, it says, Proppart said he's ranking Dillaway's performance. He's talking about his judgment, his dedication, his classroom control, his dependability. And he says, and I think I'm quoting here accurately, but if not, I'm paraphrasing. When I last observed him, he was quite a creative guy with a flair for art. He did well with the kids. He liked him. What that says, or what that would allow a reasonable juror to find, is that Proppart, a district official, was visiting this guy while he was teaching, which is totally consistent with the Constitution. There were supervisions, there were visits, and he was in a position to evaluate him. He didn't say, ask the people at St. Peter's, I don't know what kind of guy this was. He wasn't just going to bat for him after the fact, but he was visiting him in real time, which is what the Constitution said he was empowered
And I
to do.
understand you're not saying that goes to notice because it occurred after the fact, but it just showed greater degree of involvement than they seem to claim. Can I get back to the, if I heard you correctly, you said Article 13, the Constitution indicates a forfeiture of property from a local congregation.
Yeah.
Did I hear that right?
I can pull it up if it would be helpful.
Yeah, page 585.
585. Thank you so much, because I'm not that good on the fly.
And I see the language that you might be referring to.
Okay.
Or could you point to me where it says congregation's property, a local church, their real property or whatever they may have, vehicles gets forfeited to the district or to the LCMS?
It doesn't specify what property. It says because their expulsion of those so expelled forfeit their membership and all share, or sorry, because of their expulsion, those so expelled forfeit their membership and all share in the property of the synod.
Right,
The latter
the synod, right? Is that the same as property of the congregation?
The answer is it's unclear just the extent to which the property that can be seized. It's just clear that whatever property they have in the synod
I
can be
read that as like, you have our stuff. If you don't follow our rules, we want our stuff back. But I don't know. I mean,
my best understanding of it, and as with any appeal, there are always facts that are crystal clear and others where you can draw reasonable inferences. It appears from the records that were provided by the and you can see there's a record, page 545, that there's a debt service. My best understanding is that the synod lent money to its congregations, and there seem to be provisions for that throughout the Constitution that they could do that, and that that there could be financial consequences, whether it's seizing the actual church property or whether it's seizing other monies that have been loaned to them. That I can't say with precision, but there are teeth to these provisions, just as there were in PB 20, and that would ultimately be for a juror to decide at trial. The decision below denied them that opportunity. But I'd like to talk, I'm happy to focus on either notice or duty. I think they do tend to bleed together somewhat. But I would note on the question of notice that the defendants here proffered, it's really very similar to the Quitco case, which the defendants relied on a trial level decision below, and it actually got reversed on appeal. But in Quitco, you had a situation that was much, I think, probably weaker for the plaintiff than this. It was a summer camp in the 1980s. The camp owners had died. The plaintiff brought an action under the CVA. There wasn't a whole lot of evidence one way or the other on notice. And the defendants moved for summary judgment saying, we don't have any files. So what we have, there's no evidence of notice, basically putting the burden on the plaintiffs rather than the defendants. And the defendants heavily relied on this case below. They even attached it so you can have a trial decision. That has been reversed by the Second Department in Quitco. And there are myriad cases since then by the Second Department, which I think are consistent with this court's jurisprudence and that of the Court of Appeals on you can't rely on affidavits from people who lack knowledge or are conclusory. And I will note that on the issue of notice, what you have is SIAS or CS, and then you have Reverend Wicker, and they're basically saying we don't see any evidence of notice, right? Problem being, one, neither of them were alive at the time. There's no indication they talked to anyone who had knowledge. Two, there's extensive evidence that this was known within the congregation, including by the St. Peter's representative who saw the abuses or heard about the abuse as a little girl. So it was known, it was reported by BG, our other client. There's ample basis for finding that if you're supervising this church, it wouldn't have taken too hard to find it, because this individual on scores of occasions, multiple times per week, were leaving children in charge of the classroom. He was groping children in plain sight within the classroom. Then he was pulling children away, BG and my client and at least two others, into private areas where he would strip them and engage in unspeakable acts with them. So, there's ample basis for notice here that didn't exist in Quitco. And I think the second department was exactly right, and what it did was consistent with New York law, which is it's the defendant's burden to show the absence of notice. It's not the plaintiff's burden to show that there was notice, although we could if we had to. I'd also notice there's a destroyed file, right? So we've got a lot of evidence about notice here, including the dumb bunnies admission by Mr. Kruppart, right? Like after the fact, he didn't say, oh my God, what a terrible thing. He said, dumb bunnies we should have realized that this man was having problems. I think that's record page 1024. Judge Chimes just ignored it. That comment speaks to, it speaks to issues of supervision and control, and it also speaks to notice, right? It's like after the fact, a few months later, weeks later, if someone says, I really shouldn't have had that drink before getting into the car, and they engage in negligent homicide by driving into someone. How is his admission months later not relevant, right? That speaks to what happened during real time, and it's admission of the defendant, and the district is an arm of the synod. I would just, if I could, I want to just point out a few more provisions of the Constitution, because I understand that's where the court's focus are. And I would note they're within our brief, but just a couple of them that I think really almost directly mirror what was going on in PB 20. So page 583 is critically important for the Eastern District. It talks about supervision. It talks about the power to investigate. It talks about the power to suspend. Article 12 and 13 of the Constitution, which I talked about, reflect those powers. Record pages 641 to 642 talk about the role of the defendant's representatives in looking over and paying attention to issues of salaries, management, and attendance. The Dillaway's file, as I said, reflects that there were evaluations of him done by Kruppart. Patty Zostro, the representative of St. Peter's, taught in the 1970s, and she actually recalled the district coming in and supervising, right? She said, when I taught, the district would come and watch me teach. They were observing like a board of education, which their constitution said that they had, right? So you have a board of education being created at this level, bless you, with local implementation by your agents at this level, and a record showing that in fact, bless you, in the 1960s for Dillaway and in the 1970s for Patty Zostro, these visits were happening. They were evaluating people and they were intervening when they had to. And when they didn't intervene, they expressed regret and their own fault for not having realized earlier that this person they were supervising was molesting children. And then remarkably, you have these defendants going on to promote his career and say he didn't hurt kids.
Didn't the district also have a situation where there was a process in the Constitution where there could be appealed a decision? So didn't the district then oversee this appeal?
It's actually, it's exactly like in PB 20. It is a joint enterprise between the middle level of the church and the higher level of the church. And that's, I forget the record pages, but it's at about page 100 to 110 of the Constitution, right? And so what happens is if a district, if a congregation has a pastor and someone's not happy with a decision about whether or not the person should remain there, there's a process of appealing exactly as exists in PB 20. And the highest level of appeal is to the LCMS. It's to the highest level of the church. So just like your honors found in PB 20, that the ELCA was involved in the disciplinary process, here the LCMS is as well. They oversaw appeals.
Right.
Beyond that, just a few provisions on the LCMS, since I'm trying to do two at the same time. The Articles of Incorporation also reflect that they have their objects include to exercise supervision over pastors and teachers, not just as to doctrine, but also as to practice and performance of their official duties, right? So it's not just, are you praying well? It's also, are you behaving well? How are you doing things? Are you performing your official duties properly? That's record page 572. In the 1966 Constitution, the objects of the synod include supervision of teachers of the synod. And when C.S. was asked about these provisions, and he's a real latecomer, I think he came on the scene 2009, 2016, so he has no knowledge of this period whatsoever. And, yet the court is considering his affidavit below from the 2016 timeframe and disregarding evidence from 1970, 1971, 1972 coming from Dillaway's file, which makes no sense. Either the later in time testimony of Wicker and Zostro and everyone is relevant, in which case there's a fact issue. Or if you don't consider the later in time evidence because it doesn't speak to anything, then they should, then you should be disregarding the defendant's affidavits because they don't have relevant knowledge of that time period. I don't know if I'm expressing that as clearly as I could, but
You did put that point in your brief and.
yeah, there's a fundamental inconsistency between the defendant's positions and the court's position below, which is she ignored everything after this man was arrested in Dillaway's file, which tended to show evaluations and visits by the district personnel. She just sort of said, I'm not going to consider that. And yet she entertained affidavits from people who came on the scene so much later. Now, if you read Wicker's deposition in particular, and Patty Zostro, who was within this church for many years, what you see is that, that there are boots on the ground. There's enough, as in PB20, for a reasonable juror to look at this and say, you know what? They were controlling it because they could suspend, they could investigate, they could visit, they did visit, they were in a position to evaluate. This is for the juries to decide, right? And different jurors might go different ways on this record, but that's okay. That's why we have jurors. But the judge below just didn't give them that opportunity. And respectfully, we believe that was error. Just a couple more points in the record, just record sites that I think would be helpful as to the LCMS. One is that its functions including watching for movements and tendencies which may endanger the programs, assisting district boards in supervising and directing all formal educational activities. So they're supposed to be watching out for movements that are going to endanger educational programs. Well, Dillaway was endangering educational programs by molesting young girls, 7, 8, 9-year-old girls, 3 times a week, 4 times a week. So that's record page 702. Like the ELCA, the LCMS also was involved in the disciplinary process for teachers, including appeals. And I actually have a cite on that. It's record pages, I believe it's 664 to 667, just like in PB20. The defendant's constitutions and bylaws also provide, and there are points where CS seems to be throwing the district under the bus. And I ultimately think it's a fact issue for the jury which ones, and there could be multiple, were employers or otherwise owed a duty, right? You can have more than one employer under New York law. That's well established. But there are points where CS seems to be saying, well, that's really the district's responsibility, not the LCMS. And what I would say to that is, one, to the extent that the LCMS is suggesting that the district is responsible, that's even more reason why it should go back down as to the Eastern District, right? If the top of your church is saying discipline is handled at the intermediate level, then that intermediate level really should not be thrown out from the case. But beyond that, if you look at it, the constitution of all 3 defendants says the district is, quote, the synod working in a geographic area, and that the Lutheran Church Missouri Synod is not, quote, merely an advisory body in relation to the district, right? And if you listen to Pastor Wicker, the district's representative, he agreed with that. And in real time, he said, look, when the synod makes a decision, the understanding is that the districts will get behind that, right?
Because they don't want to lose their membership.
I think they just didn't have a choice back in the
membership,
day.
not operations. You can still operate. There's a difference between, I think, membership and operations as a church. I don't know. Lose your membership and still operate and hire teachers. I guess that's their argument.
I suppose the defendants could try and argue that factually. I will say, when I look at the Constitution and when I look at Wicker's testimony, to me, it's very clear to the point that we could have moved for summary judgment, that the district is an arm of the synod. The district's name can be changed by the synod. Its geographic boundaries can be changed, well, according to the Constitution, by the synod. It's an agent of the synod, or at least that's a jury question, right? But the Constitution and its, not just the Constitution, Reverend Rickler said, when the synod tells us what to do, the understanding is we do it. So I think there's more than enough evidence from the Constitution and the testimony to support that.
This case is going to trial against St. Peter no matter what.
I guess there's always the possibility that it settles, but yes, otherwise.
That's the track it's heading.
My
We're here. Not that's relevant legally. You want more pockets, deeper pockets? Because St. Peter's is closest. So if there's notice and there's clearly hiring and firing, you don't have those issues there.
Yeah,
you still got to prove notice at trial, but
what I would say, I
why are we
expect, but I
here
don't
on
know.
this, I guess is what
I'm sorry.
I guess why are we here with these 2 other defendants?
Well, you could say the same thing in any multi-defendant case, right? Including PB20, which had 3 layers of the church. There are a lot of situations, asbestos litigation, right? You have joint tortfeasors. Multiple people in different ways contribute to harm. And New York law has long recognized you don't have to be the only cause or the sole cause. You have to be a substantial contributing factor. We respectfully submit on this record, there's absolutely no legal or factual reason why these defendants should be out. The idea that, well, maybe we'll recover against St. Peter's, I think there may be practical problems with that. I don't know what the resources are of that particular entity, but the plaintiff shouldn't be limited from pursuing actions against
Right, no, I agree.
a tortfeasor.
If they're legitimate claims. So, all right, well, thank you.
Thank you very much. I apologize for being a little long-winded, but
That's all right.
okay.
A lot there.
Okay.
May it please the court. Mark Delapost on behalf of the Lutheran Church, Missouri Synod, which I'll refer to as LCMS by shorthand. One of the tactics that has been taken from day one by the plaintiff is just saying the defendants and making it one big conglomerate of 3. It's 3 separate, independently incorporated entities, LCMS, the Eastern District, and a church. 3 separate corporations. There's no evidence of interrelationship of boards or anything like that. They're 3 separate entities.
Separate constitutions for the Eastern District and the LCMS, right? Or separate articles of incorporation?
Yes.
Separate constitutions too?
They have, yes.
But we only have the constitution and the articles for LCMS
Correct.
in this record, right?
Yes.
Okay.
There's also a 4th entity which has not been sued here. It's Concordia College. That is the entity that trained this Mr. Dillaway. And to the extent she's claiming training, or the plaintiff is claiming training or improper training, that's an entity, a separate incorporated entity. Now,
They, it sounded like, and I forgot to ask her this, but it sounds like they withdrew the negligent hiring claims.
I thought so too, but the judge, I think, addressed it in her decision. So that's why I'm addressing it as well.
Right.
They also withdrew actual notices against LCMS or Eastern District
Sounds like,
at the time of argument. I wanted to point out one thing before I forget. There had been a mention that Hattie Zastro said they always hired off of the roster. And if you look at page 483 of the record, she said, when I was a teacher or when I was a chairman of the Board of Education, if there was a teacher vacancy, we could either go through the call process, district or synod, or we would just hire locally from applicants. So that's not correct. They had the opportunity, the option, and they did hire whoever they saw fit, not necessarily someone off of the roster. Article 7, which is not addressed in the plaintiff's brief, relation of synod to its members. I'll just read briefly. In its relation to its members, synod is not an ecclesiastical government exercising legislative or coercive powers. And with respect to the individual congregation's right to self-government, it is but an advisory body. Accordingly, no resolution of the synod, by the synod they mean LCMS, imposing anything upon the individual congregation is a binding force. It's an advisory, LCMS is advisory as to its members.
Unless it was the word of God.
What's
Right?
that?
Unless it was the word of God.
That's the word of God. Yes, that's correct. And it's, and they can still ignore it if they want to.
Right.
They can, and their penalty is getting kicked out of the Lutheran Church, Missouri Synod. They can still operate as a church. They can still operate as a school. That's their, and St. Peter's is a voluntary member. So this is not like the Catholic Church. It is not like the ECLA or its predecessor, the ALC. It is a voluntary membership with no right on the part of LCMS to terminate or to discipline either pastors or teachers.
Did money flow upward from St. Peter's or the local congregations to the districts and then to LCMS?
Money?
Money, yeah.
The one mention that was made about loans, I think that had to do with the fact that St. Peter owned the property and they may have taken a loan from LCMS to whatever, but that's separate from being able to seize the property as had been indicated earlier.
Do you disagree with her reading of that provision that they can seize the property if they're disobedient?
Yes, I do, Your Honor.
Why is that?
And I would point out, as much as the plaintiff wants to criticize Reverend Sains, he's the preeminent historian and expert in the issues of the LCMS Constitution and bylaws. He studied, he has a divinity doctorate. He's as experienced as anyone in terms of the LCMS. And we have sworn affidavits from him, and we have business record affidavits showing that everything is put in this record in an evidentiary form.
About the fact that your opponents argue that those two individuals don't have personal knowledge of what happened around that time.
The two individuals.
Right, where you refer
Oh,
to.
well, that's true. They don't. I have to admit to that. But this is a CVA case where defendants are hamstrung in terms of proving. So if it had been a normal statute of limitations, we would have had people that come in and testify about it.
Well, look,
but we have
these articles in this handbook. I think the handbook is the articles of incorporation, the Constitution, and the bylaws speak for themselves. Whether somebody was alive at the time, or I mean,
it's true.
It's an interpretation of what is written, and so who cares if they're alive? I guess is your point when they were written.
It isn't. The structure, the interrelationship is all set forth. And Dr. Sains has testified about that and has given an affidavit about that, you know, to the extent it needs clarification. But what can't happen here is an attorney on either side, you know, giving their expert opinion on what this means. I mean, they tried to put in an unsworn letter from an expert, which was disregarded totally and should have been disregarded totally. So what we have is an attorney arguing what he or she thinks it means to as to these articles, and that should not be considered. It's a First Amendment issue, as has been discussed earlier. They have the right, the religious have the right to exercise under the First Amendment their ability to interpret and govern under their own guidelines and Constitution, and that's what they've been doing. Now, was
there an employer-employee relationship here?
The employer-employee relationship of St. Peter to Dillaway?
Isn't there an argument that your clients, the defendants, had ability to recommend employment for?
Which they did not. They had the ability to send somebody or tell somebody to go to Concordia College and get taught and put on a roster, which may or may not mean they were hired. That's the extent of it. There's no, unlike, and I heard, I was not obviously part of the PB20 or PB21 case, and I've heard a lot of talk here about how these are exactly the same cases. There's no, you know, it's even stronger here. Baloney is what I say to that.
Let's get to that if we could. What are the difference in the Constitution from the ECLA Constitution and the Constitution here with respect to, because we said there's an issue of fact with respect to the hiring and firing and supervision of the pastors in that case.
Right.
We have teachers. She says same constitutional provisions. Can you point to us where, what are the differences that would lead to a different result here than what we reached 6 months ago?
The differences are as outlined in the case there. In that case, and I said this before, but the ECLA had the right to discipline. They had the right to have a discipline committee. They had the right to terminate. Here, you have none of that.
They could not terminate in that unless the ECLA was consulted.
Well, I'm sorry, Aaron?
They could not terminate someone unless the ECLA was consulted.
Correct.
In the Nicodemus case.
That's not the case here. This is an advisory opinion, an advisory group over voluntary memberships. And the worst that can happen is they say, we don't want you as part of the LCMS anymore. That's it. And I would also point out that in PB20, and as critical as the plaintiffs are of the fact that, oh, we just put it out there and said, you know, there's no notice, there's no this, so therefore it's no, you get summary judgment. They specifically, this court specifically noted that the proof in that case by the ECLA, which met the burden in the first instance to get summary judgment, was that St. Nicodemus hired the plaintiff's alleged abuser, paid his salary, provided him with a parsonage, supervised his daily activities as a pastor, and had the sole authority to terminate his call of the congregation. That was enough for this court to determine that the burden was met. And we have done exactly that and more. Now, in that case, there were provisions of the the Constitution, the bylaws that were part of the moving papers that this court decided didn't say what they said it said, and in effect gave them the right to terminate and to discipline. We don't have that here. So we've met our burden. This is not the Quidco case. Quidco case is very, very different. It involves an employer of the alleged abuser that was on site, day-to-day activities, supervision. This is not the case here. So PB 20 is different because of that. And as was pointed out earlier, notice was not even issued an issue in that case, because notice was sort of presumed in that case because there was all sorts of evidence from the 70s, 80s, and 90s that this abuser, Douglas Thor, had abused people and that the ECLA had knowledge of it, or at least arguably could have had knowledge of it. Here, there's no such proof, none whatsoever, that we had any knowledge, the LCMS had any knowledge whatsoever.
Well, I don't know about no proof. Those letters after the fact, one letter was written in December of 1969, and then a few months later in April, the same writer is talking about how he's been sentenced, not just charged, like sentenced for molesting children. And it kind of raises the possibility, like, you don't get charged and arraigned and grand jury all in it. I mean, it suggests that these charges existed during the relevant time period of the abuse here, which is 67 to 69.
And that December 1969 letter from the district president was the first time, and it was to or CC'd to my client. Mm-hmm. There's no indication in any of those letters, the 4 or 5 letters, that the LCMS had any knowledge of it prior to those letters, and they did not authorize those letters. They did not author those letters.
But it sounds like legitimate possibility that the teacher had been charged prior to that letter being sent, right? I mean, he got sentenced in April, like 4 months later. System doesn't work.
I don't disagree with that, Your Honor, but the point is, there's nothing in those letters that implicates LCMS as having knowledge or notice of it.
Okay.
We've given the information and the documentation that we have available to us to file a summary judgment motion. In terms of a voluntary assumption of duty or beyond the employer-employee relationship, which I think clearly does not exist here, I look at that Stephanie L. case decided 4 years ago by this court. And I think that case, it talks about two-pronged test, the good shepherd, the defendant in that case, which was the employer. Again, this wasn't a second or third level entity. The good shepherd did not have actual control, and the good shepherd did not have a relationship with the plaintiff. And the central concern of in both prongs is whether the defendant's relationship with the tortfeasor or the plaintiff places it in the best position to protect against the risk of harm. The best position to protect. There's under no argument, under no reading of what the facts are in this case, can you say that the LCMS or the district is in the best position to protect the defendant? It's just not. If you read that Stephanie L. case, I don't know how you come to any other decision but what was decided by Judge Chimes below.
Well, if you look at Article 12 of the Constitution, I think, unless my handwriting is poor and I can't, maybe I'm reading the wrong room or no, I don't know.
What page is that, Your Honor? I apologize.
So I didn't write this page number down either. But it talks about the district shall exercise supervision over doctrine, life, and administration of the office of the pastors and teachers, shall visit, and I am not reading the whole quote, shall visit, hold investigations in the congregation as deemed necessary. So in a situation such as this, and as your opponent indicated, they had a responsibility, the district at least had a responsibility to go out and visit the various congregations and investigate as deemed necessary. Would that then say there's a failure, or as a reasonable parent standard, would a reasonable parent, someone in control at this point in time, look at this situation of what was going on then? There was chatter at minimum involving this individual. If they failed to do that, would that failure then, which may have led to more inclusive information, would that then extend to your client as well, up the ladder?
No, Your Honor, because as I said, they're separately incorporated entities, and it's a voluntary membership. So it does not go between the LCMS and the Eastern District. And I'll let Julia specifically address the.
That's why I asked if it would go to you then, as far as climbing up the ladder in this instance, because doesn't the LCMS then have control over where the districts are, establishing a district?
You still have to have some evidence of notice, something, somewhere. If there's just nothing here, this is very different than the PB20 case. It's very different than the Stephanie L case. There's just no evidence that there was any notification whatsoever to LCMS before this.
So even if they had gone out and done an investigation according to what the district is required to do, says shall, they didn't find anything.
Right, and notice is important because if you don't, I mean, if you say, well, we could have gone to 5,900 different congregations and done investigations, you know, we had that option, which I don't think we do under the Constitution. But even if we did, we could have gone in there. We might have seen something. That's the opposite of notice. You're taking notice out and you're making it a strict liability issue if you're going to.
Right. I guess my question again related to if they had done that, whether I climbed up the ladder to your client.
I do not believe it is.
That provision references the district. Right. I'm just wondering whether that would then climb up the ladder to your client.
If we receive notice of it, certainly, but no notice. So
this might be a good time.
We can't do anything without notice.
Might be a good time to turn it over to Mr. Hilker. Ms. Hilker.
Okay. Thanks, Don.
Thank you.
May it please support your honors, Delia Hilliker from Hatch and Ross on behalf of the Eastern District. I'm going to shortcut my outline a little bit since we've been through so much and try and get to what I think are some essential distinctions here. So first of all, plaintiff concedes in the record at page 28, actual notice. It's off the table. So with regard to the Eastern District and the other defendants sitting here, the only question becomes constructive notice. And when asked during oral argument what the constructive notice was, all they said is, well, they could have gone and investigated. Not they did, not they should have known something, not there was boots on the ground. So what we actually have in the record is they were allowed to visit if they wanted to. Dr. Wisher says that typically occurs once every 3 years because there's so many congregations. So yes, could they go in and observe? They could, but they had no ability whatsoever, as you've pointed out in the relevant constitutional provisions, to actually remove a teacher from its position. They had no say in the hiring of the teacher. As we heard, the representative from St. Peter said they could just hire locally whoever they wanted. And they had no ability to terminate the individual. They could say that they were not going to be part of the synod anymore, but the church in this instance owned the property. So the church could continue however it wanted, its school, its congregation, it could join another affiliation or not. But the Eastern District had no ability to exercise sort of such powers to threaten to take away everything that it can be considered employment in some regard. It's specifically not the case as it was in PB20.
Would this be similar then? I'm sorry.
No, please.
Would this be similar to sort of like a franchise situation where the district is Tim Hortons and you are a franchise owner, and basically employees have done something which is not out of character, whatever it might be. You don't have any control over that, would you? I mean, your responsibility is to set the menu and imaging and things along those lines.
Right. I think that's a great analogy, right? You provide the marketing materials, et cetera, but you have no say over hiring and firing. The other analogy that I think is relevant is really to think about teachers in regular schools, right? They have to go to college, they have to obtain a bachelor's degree. So some university, right, gives them their bachelor's degree. And then if you want to teach in a public school, you have to obtain your licensure from New York State. So New York State creates a list of licensed teachers from which public schools have to hire. And New York State isn't sued when one of those teachers later abuses a student. Just because you have a license, it's the same as a list, right? There's a list that says these people completed the requirements necessary to serve. And that's specific really only to pastors. Here we're talking about a teacher. You could have your certification necessary to serve. or you could be a local applicant, anyone off the street.
Let's assume that we got the prior case from June, the PB 20 case, Ms. Phillips was on, we got that correctly. Okay, let's assume that. I know you probably don't think we did, but let's.
Of course we did.
Assuming the accuracy of that, why can we go and not be inconsistent here and go the other way? What specific provisions of the Constitution in the LCMS and in the Constitution here dictate a different result?
Right. One actual notice is conceded is not an issue here.
Right, but I'm talking about the employer-employee situation.
So moving to the Constitution, Article 7, which is at Record 583, that deals only with supervision in the ecclesiastical sense, and Dr. Wisher talks about that. So that's where we get into First Amendment issues. Dr. Wisher is very clear that in application, that supervision is not day-to-day supervision of how they go about doing their jobs. It's theological supervision and how they implement that theology in their teaching. And that's where we get into First Amendment issues when you start interpreting it in a secular fashion rather than abiding by the churches.
We rejected the First Amendment claims in the last case.
But there, Your Honor, you were using the plain language of the Constitution, which said that the mid-level division had the ability to remove the pastor and specifically did not give the congregation the ability to do so on its own. Right. Here, that's turned entirely on its head.
In your view, the First Amendment issue is one difference, but the employer-employee is different as well here.
Right, so I think you can just.
Two differences.
Two differences. I think you can distinguish it first here because the constitutional provisions are different. So if you look, for example, at the record 639 to 642, there's a whole discussion about how it's advisory only. Mr. Della Posta read you some provisions from that. There is no question based on the documents here that the power to fire or hire a teacher rests solely with the congregation. I think it's at 585, let's see. 585, yes. So it says, if a member is expelled as a pastor or teacher in a congregation of the synod, such congregation, unless it has already done so, is held to depose him from office and deal with him in accordance with the word of God. It's recognizing there that the congregation might have already done so because the power to hire and fire the teacher lies solely with the congregation here. That was not the case of the provisions in PB 20. I would also point out that PB 20 had a committee of discipline. No such equivalent exists here. They can make advisory recommendations, but the Eastern District, no matter what it does, cannot stop a certain person from teaching so long as the congregation keeps them employed.
And then practically, it's a lot more feasible for the district to supervise 128 pastors, or however many pastors are in that district, than there are teachers, presumably thousands. And why, could be more than just teachers, but it's seems more practical and reasonable to supervise a smaller number of people than a larger number.
Certainly, Your Honor. Presumably every church has one pastor, maybe two, but in terms of overall workers, I mean, where do we stop? Teachers, janitors, the list goes on. It would be completely contrary to the Constitution at issue here to find that the Eastern District was an employer for any of those. The other thing I would say, and I think you've captured this already, but I'll mention it anyways. We're not dealing with a pastor here. He wasn't serving in his role as a pastor. So the church was not limited to the call list in terms of who they could hire. And I think that is a significant distinction between PB 20 and the present case.
Right. Anything further?
That's all I have, Your Honor.
Thank you very much. Case 261. Chido versus Chido. 261. Good morning, Mr. We're waiting for Ms. Barnett, and she is now here. So you may proceed.
Thank you. May it please the court, Tyson Blue for the appellant, Catherine Chido. The court below erred in dismissing Ms. Chido's petition for essentially three reasons. First being that Mr. Chido, who had only previously appeared virtually, was absent entirely on the hearing date.
And it was an oral motion that day, was it?
Yes, Your Honor.
So the father had no idea that, well, it was on for a hearing, I guess.
Yes.
And he didn't want to be there, but so your argument is that the allegations in their pro se petition were sufficient to change the circumstances, at least give her a hearing, and that we should be remitted and they start all over.
Yes, Your Honor.
It sounded like Judge Healy's rationale here was the father wasn't even involved for a couple of years, wasn't even seeing the kids, right? They had a prior order, joint custody, but she was the sole, she was the primary residential parent.
Yeah.
And her argument, the mother was like, well, the kids aren't feel comfortable with him. There's allegations of sexual abuse, all this stuff. So we don't want him to have any contact with the kids. But Judge Healy was looking at it like he's not even having contact. And under the prior order, he got only visitation as agreed to by the mother. And he said to her at the end, it said, just don't agree to any visitation. And so you're all set. Then he would have to bring a petition, the father would, so forth and so on. So it just seemed like Judge Healy was looking at, he probably has a lot of other cases. He's a three-hat judge. It's like, why are we here? The father is not seeing the kids, doesn't want to see the kids. He doesn't even show up in court. Why not just maintain the status quo, which he gets nothing? That seemed to be the judge's theory here.
I agree with that summation of the series. I think that is what he had in mind. And what concerned Ms. Chido was that in the previous appearance, when all parties in council were present, virtually or otherwise, that the judge had said that if there wasn't an agreement, he would speak with the children, and she felt strongly about that. Another factor was the fact that Mr. Erie, the attorney for the children, was also absent on the hearing date.
Mm-hmm. Is the father seeing the kid now?
Not so far as I know. He continued to not respond to any attempts at corresponding with him. And the last time I spoke with Ms. Chido, which was 2 or 3 weeks ago, she said she'd had no contact from him.
We're coming up on 5 years. The father hasn't seen the kids and is making no efforts to see the kids.
That's correct.
Yet the mother wants to go back to family court and get an order from the judge saying the father can't see the kids when he's not even trying to see the kids anyways.
Yes.
Okay. Anything further?
No, Your Honor, I'll rely on my brief.
All right. Ms. Barnett?
Your Honor, Mary Beth Barnett, the attorney for the children. Matthew is 10 and Caden is 9. The issue we're requesting this matter is returned to court. And the reason is not the fact that they haven't visited, which you're very correct on. However, there is the issue of paperwork involved, and joint custody implies that the father has some access to the medical and school records of the children, and he did make it difficult for the mother in around 2021 that he changed the health insurance for the children, didn't tell the mother, and as a result, the kids didn't have health insurance for a period of time. So we're asking that the order be able to mirror what's actually happening, in fact, primarily because of that. And the children, I would say, have no interest actually in talking at this point to the judge. However, they would feel more secure if they knew the mother had sole custody. And dad could make mischief.
He can make what? Oh, mischief. You say?
Mischief, right.
Okay. He hasn't lately, but I guess there's always that possibility mischief is coming down the road.
No, he did do that once, Your Honor.
Oh, good.
Sorry, I wasn't wasn't clear. He did change the children's health insurance after the order was in place.
Okay.
And made
All right. Well, thank you very much.
Thank you, Your Honor.
We will go to case 265, matter of the estate of Linda Sawkins. 263. Well, I'm sorry. Yes, you're correct. I want to keep skipping cases here today. 263 and 264 Erie County DSS versus Candace F. And we have the appellant is submitted. We have virtual two attorneys who are one has appeared. Waiting for Miss Fortin. There she is. Miss Maricelli, you're asking us to affirm if I read your papers correct?
That is correct, Your Honor. Shelby Maricelli for the Department of Social Services. Very briefly, because I know it's been a long morning, we would just, it's the department's position that the trial court's decision was correct, and we would otherwise rest on papers unless there's any questions from the court.
Thank you. Ms. Fortin, you were asking for the same relief?
Yes, Your Honor. Just a few things. May it please the court. Claire Fortin from the Legal Aid Bureau of Buffalo on behalf of the three children, Ethan, Tristan, and Summer, in this appeal. I will rest on my papers as submitted today, but I am happy to provide an update on the children.
Please do.
Okay. So there were subsequent petitions filed after this appeal and against the appellant, and the court found it fit to appoint a separate attorney for Tristan, the baby, but we do still represent him in the appeal. So I have had a chance to talk to Tristan's AFC and get an update on the baby. All three children are doing extremely well. They're living with mom. They're thriving. Tristan, as the baby, is very, very bonded with mom. Ethan and Summer are attending school regularly and doing very well at school. All of the children are medically up to date, and at this time, we do not have any concerns for the children.
All right. Well, thank you for that update. We appreciate it.
Thank you, Your Honors.
Case 265, matter of the estate of Linda F. Sawkins. Appellant has submitted. Respondent's counsel is arguing remotely. Mr. Vaccaro, you unmute yourself. You may begin. Your opponent has submitted.
Thank you, Your Honor. Good morning, Justices. My name is Mike Vaccaro, and I'm representing the respondents on this appeal. All of the parties to this litigation are children of the decedent. The appellant was serving as an agent under a power of attorney that the decedent executed back in 2016. Our clients requested her by petition to account as executrix of the estate and as agent under that power of attorney. She provided an intermediate accounting for the estate, claiming that there was a pending lawsuit that prevented a final accounting. She refused to account as agent under the power of attorney. There are two statutes involved. I'm sorry?
Well, yeah, we're familiar with GOL 5-1505 and GOL 5-1510. And the issue of standing as a child, as a petitioner, are children of the decedent, of the principal. The argument is they don't have standing to ask for a copy of the records of the disbursements and the receipts and the transactions. The court granted the petition, and now there's an appeal they submitted. Has that record, the accounting, been provided? The order said it must have been filed within 45 days. The order was issued in March of last year. Has that been turned over?
No, the appellant persists in her refusal to account as agent under the power of attorney. The motion court, in order for her to make that claim, she relied on what we contend is a misapplication of the interaction of those two statutes. And the court below accepted that, said that her interpretation was inappropriate, and the effort was to avoid accounting as agent under the power of attorney. The statutes, particularly 1505, are clear that as an agent under a power of attorney, she's a fiduciary and she's obligated to account. In fact, that statute defines to an extent the content of her fiduciary obligations, but also is clear that it's not an exclusive listing, and that generally as agent, she's obliged to account as a fiduciary. Section 15-10 is clear at subdivision 3 that children of the principal have the right to demand an accounting from the agent. And that has been addressed in 2 cases, one of them by this court, where in Jewish Home, a healthcare facility was looking to discover assets in the hand of an agent and commenced a proceeding. That agent moved to dismiss the proceeding, claiming that there was no standing, and this court, noting that subdivision 3 provides that anyone who's going to be required to accept a power of attorney can request an accounting.
Well, may I, Counselor, you keep using the word accounting. When I read the statute, I think you're under 515-10-3 sub E. That's to approve the record, right? You have your position is that your clients have standing to bring a special proceeding in the surrogate's court to approve the record. And I understand that. So your position, that's the functional equivalent of an accounting. Is that right?
Yes, and I think the cases are clear on that is the case.
So that's different than what other interested parties, so to speak, would have the right to under 515-10-1, which would be the production of, for lack of a better word, books and records. Right?
Well, 1505 concerns the rights of the principal. It concerns the rights of people he designates, and it concerns the rights of certain quasi-governmental.
Maybe I wasn't clear. The way I understand it is the surrogate ordered an accounting.
Yes.
To be produced within 45 days. And the statutory basis for that was 515-10-3 sub E to approve the record. And so when the accounting is presented here, the surrogate still has jurisdiction to approve that. In other words, potentially surcharge or otherwise provide a release to the fiduciary. That's your position?
Well, no, the position in our petition was a little bit broader than that. Our clients demanded a full accounting by the agent under the power of attorney.
Right, but where in the statute does it say that your clients as children get an accounting? 1505 talks about an accounting, you get a copy of the record of books, but your clients don't have standing as children under 1505, therefore they don't have standing under 1510-1. Justice Delcante's pointed out they do have standing as children under 1510-3 and 2, but that is to request the court to approve the record. Doesn't say anything about an accounting. Your argument, as suggested by Judge Delcante, is that it necessarily follows for the court to approve it. The agent who has the power of attorney has to make an accounting, because otherwise there's nothing to approve. So even though that it's a functional equivalent is the argument Justice Delcante made, and I think that's the only way you can win here. So I was expecting a yes out of you out of that.
Well, yes, we agree with that.
Okay.
We agree with that, and I'm sorry if I misunderstood what Justice Delcante was saying, but we submit that what the agent under the power of attorney is obligated to provide is a full accounting, including that record that's provided for in the statute of her receipts, disbursements, and all of her transactions. And
Great. Counsel, your camera's a little bit off here, and we have a gentleman sitting there listening carefully to you. Is that what's going on there?
I'm sorry, Your Honor. That's my omission. I should have that's my colleague, Richard M. Stordo, Esquire. He and I are working together on this file.
Okay.
And
yeah. As long as
he's
we just can't have tripping in,
honest.
all right? Just under our rules, you can only have one. So, I mean, it sounds like he's just listening and we're good, but it looks like he has some thoughts there that he wants to share. I just want to make sure he keeps them to himself back there. All right. Anything further?
Well, yes, Your Honor. I think the case law is pretty clear that under a fiduciary, such as an agent under a power of attorney, owes an extremely high duty of loyalty, fair dealing, and complete candor to the principal. That's a bedrock of fiduciary law, and cases hold that an agent under a power of attorney is a fiduciary. Without the right,
one thing is clear. Look, one thing is clear. I think you would agree with this. Even though they don't have standing to demand a record of the receipts, disbursements, and transactions, although as children they don't have that. Independent of that, under 1505, anyone who's a power of attorney acting on that has a duty to keep a record, to keep it.
I
So
agree with that.
So the agent, unless she violated her fiduciary duties, should have this record and should have all these records. And just a question of should she turn them over to the court because the court needs to approve them. And unless the court sees them, court can't approve them.
Well, as I said, Justice Lindley, we believe that the duty of the agent to account is broader than that, because the only protection that the beneficiaries have is by way of an accounting by the agent under the power of attorney. Absent that right to an accounting, they're at the mercy of a rogue fiduciary who wants to do whatever he or she wants without any oversight whatsoever. Now, in this particular case, as the counter statement of facts in our brief pointed out, there's some significant concern here.
Counselor, let me see if I can clarify what I think you're asking here. And the statutory section may not use the word accounting, but it's the functional equivalent of an accounting. And an accounting is two things, at least in my mind: reporting what the transactions are, and then explaining the transactions. It isn't simply just producing the books and records. An accounting would require the fiduciary to explain how those monies were spent for the benefit of the principal. And that's what the surrogate ordered here.
Yes, that's correct.
Right.
All right. Well, we appreciate your time, and your colleague there was listening carefully in the background. Thank you very much.
Thank you.
We will now move to case number 270, Nesterenko versus Hall. Nesterenko may or may not be joining us virtually, as is counsel. Mr. Hauk is here for respondent. We've been advised through our technical services department that there may be a problem with our pro se plaintiff connecting with us. So we'll give him a moment here.
Judge, we do have him on the call. We just don't know that he's able to speak. So we're working that out. It might take a moment.
Yeah.
All right, Judge, I believe we have him.
Mr. Nesterenko, you with us? Vladimir? If you can hear me, unmute if you have a mute button going.
Judge, he's on the call and he's unmuted. At this point, there's not much else on this side that we can do with him.
Right, I understand. Mr. Hauk, your opponent has involuntarily submitted. Do you? Oh, he's here now. Okay. Mr.
Do you hear me?
Yes, we can.
Hello?
Yes,
Do
we
you
can.
hear me?
Yes, sir.
Okay. May it please the court, my name is Vladimir Nesterenko, and I am plaintiff pro se appellant in this matter. This is a medical malpractice case. Let me introduce the parties. Plaintiff pro se appellant Vladimir Nesterenko is a 71-year-old disabled person with a very serious heart illness. It's incurable and terminal with a limited life expectancy. Most of the time, he stays in bed or in chair. Defendant respondent Burr Hall, MD, is a physician with a specialty in cardiology, including subspecialty in electrophysiology. He is affiliated with a Strong Memorial Hospital. In the defendant's affidavit, he stated, I have been the principal physician monitoring the plaintiff's ICD to ensure their functioning properly. Your Honor, I have a question for you. I submitted to the court my oral argument in writing, and the same I submitted my oral argument in writing to both attorneys for defendants. Should I continue reading my oral argument because I got it in writing?
Yes, we did receive that, Mr. Hauk, with his consent. He consented to that procedure, which is a little unusual, but he was kind enough to do that. So yes, we do have the letter that you are reading now. So if you want to finish that up, we wait to hear it. I'm sorry?
Asking, Your Honor, I'm asking, is it possible to use my oral argument in writing, like
sure.
my oral argument, so I don't have to read it
again?
again?
I don't think there's any opposition from the panel on that one to just rely on what you submitted. So that would be.
I don't understand you. Is it possible or not?
Yes. Yes. You don't have to read it here today. We have it.
Okay.
Okay. So we thank you though for your time.
Okay. So I'm glad to answer all your questions, Your Honors.
Yeah, I think your written submission was quite thorough. I personally don't have any questions. The panel does, so we appreciate the effort you put into that, to your brief and into your written remarks there. So thank you very much.
Okay. Thank you.
You're welcome. Mr. Hauk, do you wish to be heard on this one?
May it please the court, Michael Hauk on behalf of respondent Dr. Hall. It's our position that the lower court decision was correct, and unless there are any questions from the court, I would rest on our submission.
Hearing none, thank you.
Thank you.